Hello, welcome back to Let's Talk Title with Emerald Coast Title Services. I'm host and president of ECTS, Dion Moniz.
And I am the Director of Operations and a licensed title agent, Ashley Bowen.
All right, so today we're going to give you an update to what we have called Surfside legislation, or the new condo law. Granted, there's a lot of condo laws, but so Surfside legislation is the law that went into effect in May of 22 that now requires milestone studies and SIRS reports to be done on condos.
Mm-hmm.
So they've been some changes, some tweaks to that law. So previously, if the condo building is within 3 miles of the coastline, 25 years of age was the threshold. Outside of 3 miles, 30 years of age was the threshold. But that's recently been changed, right, Ashley?
It has. Well, they have changed it to 30 years unless across the board, unless the local building enforcement agency decides that they want it to be done at the age of 25 years. Here in our local counties, we've asked around and done a little bit of research, and it appears that Walton County is going to stick with that 30-year mark, and so those buildings don't have to have the initial milestone inspection done until the building reaches age 30. But we have been told that the building officials in Bay County as well as Okaloosa counties are requiring that 25-year mark.
Yeah, so Walton County is going with the new change. Bay and Okaloosa are sticking to the original version, which is 25 years if inside 3 miles of the coastline, which is pretty much
all of them
for those counties. So interesting to know, for the condos that get to wait another 5 years, that gives them 5 more years to build up reserves for the issues that are probably or may come up on the milestone. And as a refresher, the milestone is where they have to go and do a structural inspection of the building. And there's a phase 1. If phase 1 is clear, nothing else has to be done. If phase 1 comes up with something, they have to do a more destructive, more thorough testing, which is a phase 2. And that's where they figure out what all has to be fixed. And then
there's also a SIRS study that has to be done.
Yeah, and we'll touch on that in just a minute. But with regards to milestones, across the board, once one is done, then it's every 10 years thereafter, and that hasn't changed.
The milestones, okay.
Yeah.
And then the SIRS, that is a structural integrity reserve study. So that is not an inspection of the condo itself. That's going to be an inspection of the reserves of the association's bank account and seeing how much money they have. And then that is where they have to have buckets of money for each different of the 10 elements that make up the SIRS, which are roof, floor, load-bearing walls, fireproofing and fire safety, exterior painting and waterproofing, plumbing, electrical systems, foundation, windows, and other elements over $10,000 that have any impact on the structural integrity of the building.
Yep. Yeah, so the condos are no longer allowed just to put those off. They have to show that they have adequate reserves in place to handle these items when they're ready or due.
And that study has to be performed every 10 years because it makes sense. Just like you should have your homeowner's property insurance, you should readjust that every year or every 2 years. They also have to readjust and look at this reserve study because things change. The cost of replacing a roof in 10 years will be different than it is today.
Yeah, absolutely.
So forth.
So, and if you want to read the full statute for some good bedtime reading, the SIRS is handled under section 718.112. So you can get the full text of that. But yeah, just keep in mind it's every 10 years, and we're seeing a lot of these monthly, or not monthly, but the routine assessments for condos have gone up. Special assessments are being imposed to handle all of these reserve issues now that are now required under the SIRS.
I feel like we're coming, though, on the downward slope of it. I think that we've, everybody's had, all the condos have had their milestone studies, inspections done, and their SIRS studies, and they knew how much that they're going to have, and then the special assessments have gone out. And so I think that we're going to be on the downward turn of the heartache that the Surfside condo falling caused.
Yeah. Unless you have some other structures that are coming up on that 25 or 30-year mark and have issues that weren't known or suspected, because those have to be done. Those have to be handled immediately.
There have been some hefty special assessments come out over, 6 figures in a couple of different complexes per condo unit.
Yeah, so if you're in the market for a condo, there's a little more due diligence you have to do now, and the association is now required as part of the condo disclosure that the seller provides. The association has to provide a copy of the milestone, or at least a statement that the milestone hasn't been done yet.
To all owners, so the seller should have a copy of that document.
Right.
The association will not provide it to the buyer or the buyer's realtor. It'll have to come from the seller. So the seller or listing agent, have your seller request one, and so that you guys have it in your book of documents to provide to your potential purchasers.
Yep, absolutely. So the full statute that covers the milestone inspections is 553.899. And there's one more change that they're making to that statute, which goes into effect July 1. And so previously, any structure that's more than 3 stories above ground is subject to the milestone. If you're 3 stories or less, and if it's 1, 2, 3, it was 1, 2, or 3 family dwelling buildings, then you're exempt. But they're going to change that to 1 to 4 family dwelling units with 3 stories or less is exempt. So if it's 3 stories or less, but more than 5 family dwelling units, then it still qualifies for the milestone. But if it's 4 dwelling units or less, 3 stories or less, then as of July 1, it's exempt.
So I think then that particular rule, I think it does impact 1 or 2 complexes on Scenic 98 in Walton County. So that was a good change for our area.
Yeah, exactly. And we went through all this initially at episode 28. So if you want a refresher, you can hit that. Otherwise, we just wanted to give you the quick updates that are in the pipeline for those 2 statutes. So if you have any questions, feel free to contact us, and we'll be glad to answer any additional questions. As always, please like us on our social media channels. And until next time, we'll see you later. Bye-bye.